Wrongful execution is a miscarriage of justice occurring when an innocent person is put to death by capital punishment. Cases of wrongful execution are cited as an argument by opponents of capital punishment, while proponents say that the argument of innocence concerns the credibility of the justice system as a whole and does not solely undermine the use of the death penalty. Today we are looking at some people who were executed but possibly innocent. Please subscribe to the channel and like the video. First on the list, Carlos DeLuna, convicted in 1983 and executed in 1989. On December 7, 1989, Carlos DeLuna, a young Latino man, was executed for the 1983 murder of Wanda Lopez, a gas station employee in Corpus Christi, Texas, despite his persistent claims of innocence. At the time of his execution, he was only 27 years old. During his trial, prosecutors dismissed DeLuna's assertion that an alternative suspect, Carlos Hernandez, was the true perpetrator. They labeled Hernandez a phantom suspect, suggesting that DeLuna had fabricated his existence. DeLuna's conviction and subsequent death sentence were predominantly based on eyewitness misidentification. The prosecution's characterization of Hernandez inspired the title of a haunting documentary that premiered at the Tribeca Film Festival on June 14th and is scheduled for release on Netflix on September 30th. Titled The Phantom, the documentary draws from a series of interviews with DeLuna's family, his trial attorney, prosecutors, and eyewitnesses, casting significant doubt on his conviction and unveiling new, troubling evidence that suggests his innocence. It follows a reinvestigation led by Columbia law professor Jim Liebman and his team, who documented their findings in a book titled The Wrong Carlos, as well as in an article for the Columbia Human Rights Law Review. The Phantom paints a stark picture of the U.S. criminal justice system, which has disproportionately impacted the Latinx community and those living in poverty. DeLuna grew up in a low-income neighborhood in Corpus Christi as one of 3 children raised by a single mother, in an environment where violence was commonplace and residents faced capital murder charges with minimal legal support. The documentary also highlights the investigative shortcomings, including law enforcement's failure to pursue credible alternative suspects and the inherent unreliability of eyewitness testimonies. 2. Ruben Cantu, convicted in 1985 and executed in 1993. A 2-part investigative series by the Houston Chronicle has raised significant doubts about the guilt of Ruben Cantu, a Texas man executed in 1993. Cantu, who was just 17 years old when charged with capital murder for the shooting of a San Antonio man during an attempted robbery, consistently maintained his innocence. Recent statements from both the prosecutor and the jury forewoman have cast further uncertainty on the case. Additionally, a key eyewitness and Cantu's co-defendant have come forward, asserting that Texas executed an innocent man. Juan Moreno, the injured eyewitness in the robbery, now claims that Cantu was not the shooter. He stated that he only identified Cantu due to pressure from law enforcement and fear of repercussions. Moreno recounted that he had told police twice that Cantu was not the assailant, but they persisted in pushing him to identify Cantu after he was implicated in an unrelated police shooting. The police were sure it was him because he had heard a police officer. They told me they were certain it was him, and that's why I testified. It was wrong to blame someone who wasn't there, Moreno told the Chronicle. Furthermore, David Garza, Cantu's co-defendant from the 1985 trial, has recently signed a sworn affidavit admitting that he allowed Cantu to be wrongfully accused and executed, even though he was not present during the crime. Garza expressed deep remorse, stating, "Part of me died when he died. You've got a 17-year-old who went to his grave for something he did not do." Texas murdered an innocent person. Sam D. Millsap, Jr., the Behar County District Attorney who prosecuted Cantu, acknowledged that he should never have sought the death penalty based on an eyewitness account that relied on a photo identification shown to the witness 3 times. Miriam Ward, the jury forewoman in Cantu's trial, reflected on their decision, saying it was the best they could do with the evidence at hand. She lamented, "With a little extra work, a little extra effort, maybe we'd have gotten the right information. The bottom line is, an innocent person was put to death for it. We all have our finger in that." 3. Larry Griffin, convicted in 1981 and executed in 1995. A year-long investigation by the NAACP Legal Defense and Educational Fund has uncovered evidence that Larry Griffin may have been innocent of the crime for which he was executed by the state of Missouri on June 21, 1995. Griffin maintained his innocence until his death, and investigators say his case is the strongest demonstration yet of an execution of an innocent man. The report notes that a man injured in the same drive-by shooting that claimed the life of Quinton Moss says Griffin was not involved in the crime, and the first police officer on the scene has given a new account that undermines the trial testimony of the only witness who identified Griffin as the murderer. Based on its findings, the NAACP has supplied the prosecution with the names of 3 men suspects committed the crime, and all 3 of the suspects are currently in jail for other murders. Prosecutor Jennifer Joyce said she has reopened the investigation and will conduct a comprehensive review of the case over the next few months. There is no real doubt that we have an innocent person. If we could go to trial on this case, if there was a forum where we could take this to trial, we would win hands down, stated University of Michigan law professor Samuel Gross, who supervised the investigation into Griffin's case. 4. Joseph Odell, convicted in 1986 and executed in 1997. Recent DNA blood evidence has raised significant doubts about Joseph Odell's conviction for murder and rape. In a 1991 review of his case, 3 Supreme Court justices expressed skepticism regarding Odell's guilt and questioned whether he should have been permitted to represent himself. Absent the blood evidence, there was minimal connection between Odell and the crime. In September 1996, the Fourth Circuit of the U.S. Court of Appeals reinstated his death sentence and upheld his conviction. The U.S. Supreme Court declined to review Odell's claims of innocence, ruling that its decision about informing juries of the alternative life without parole sentence was not applicable to his case. Odell requested DNA testing on additional evidence to support his innocence, but his request was denied. He was executed on July 23rd. 5. David Spence, convicted in 1984 and executed in 1997. David Spence was charged with the murder of 3 teenagers in 1982. He was allegedly hired by a convenience store owner to kill another girl, but mistakenly killed the wrong victims. The store owner, Munir Deeb, was initially convicted and sentenced to death, but was later acquitted in a retrial. Marvin Horton, the police lieutenant who oversaw the investigation into Spence, eventually stated, "I do not think David Spence committed this crime." Ramon Salinas, the homicide detective who conducted the investigation, echoed this sentiment, saying, "My opinion is that David Spence was innocent. Nothing from the investigation ever led us to any evidence that he was involved. There was no physical evidence linking Spence to the crime. The case against him was driven by an overly aggressive narcotics officer who relied on the testimony of prison inmates who were given favors in exchange for their statements." 6. Leo Jones, convicted in 1981 and executed in 1998. Jones was convicted of murdering a police officer in Jacksonville, Florida. After several hours of intense police interrogation, he signed a confession, but later asserted that it was coerced. In the mid-1980s, both the officer who arrested Jones and the detective who obtained his confession were removed from duty due to ethical violations. One officer later labeled the arresting officer as an enforcer who had employed torture tactics. Additionally, numerous witnesses came forward, indicating another suspect in the case. 7. Gary Graham, convicted in 1981 and executed in 2000. On June 22, 2000, Gary Graham was executed in Texas, despite claims that he was innocent. Graham was 17 when he was charged with the 1981 robbery and shooting of Bobby Lambert outside a Houston supermarket. He was convicted primarily on the testimony of one witness, Bernadine Skillern, who said she saw the killer's face for a few seconds through her car windshield from a distance of 40 feet away. 2 other witnesses, both who worked at the grocery store and said they got a good look at the assailant, said Graham was not the killer but were never interviewed by Graham's court-appointed attorney, Ronald Mock, and were not called to testify at trial. 3 of the jurors who voted to convict Graham signed affidavits saying they would have voted differently had all of the evidence been available. 8. Claude Jones, convicted in 1989 and executed in 2000, DNA tests raised serious doubts about the conviction of Claude Jones, executed in Texas in 2000. The test revealed that a strand of hair found at the scene of a liquor store shooting did not belong to Jones, as was originally implied by the prosecution. Instead, the hair belonged to the victim. Jones was executed for the murder of the store's owner. The strand of hair was the only piece of physical evidence that placed Jones at the scene of the crime, and this revelation raises the question of whether Texas executed the wrong person for the murder. Before his execution in 2000, Jones's lawyers filed petitions for a stay with both the district court and with the Texas Court of Criminal Appeals, requesting that the strand of hair be submitted for DNA testing. The necessary DNA technology had not been developed at the time of the crime in 1989, but was available in 2000. Both courts, along with then-Governor George W. Bush, denied Jones a stay of execution. Apparently, Governor Bush was not even informed by his clemency advisors about the request for the DNA test. Barry Scheck, co-founder of the Innocence Project, said, "The DNA results prove that testimony about the hair sample on which this entire case rests was just wrong. Unreliable forensic science and a completely inadequate post-conviction review process cost Claude Jones his life." In 2007, the Innocence Project, along with the Texas Observer, the Innocence Project of Texas and the Texas Innocence Network, filed a lawsuit to obtain the hair for DNA testing. In 2010, Judge Paul Murphy ruled in favor of the Observer and the Innocence groups and ordered prosecutors to turn over the evidence for DNA testing. Dwayne Jones, Claude Jones's son, said, "Knowing that these DNA results support his innocence means so much to me, my son in the military, and the rest of my family. I hope these results will serve as a wake-up call to everyone that serious problems exist in the criminal justice system that must be fixed if our society is to continue using the death penalty." Jones was one of the last inmates executed before Governor Bush left office to become president. 9. Cameron Willingham, convicted in 1992 and executed in 2004. After examining evidence from the capital prosecution of Cameron Willingham, 4 national arson experts have concluded that the original investigation of Willingham's case was flawed, and it is possible the fire was accidental. The independent investigation, reported by the Chicago Tribune, found that prosecutors and arson investigators used arson theories that have since been repudiated by scientific advances. Willingham was executed in 2004 in Texas, despite his consistent claims of innocence. He was convicted of murdering his 3 children in a 1991 house fire. Arson expert Gerald Hirsch said, "There's nothing to suggest to any reasonable arson investigator that this was an arson fire. It was just a fire." Former Louisiana State University fire instructor Kendall Ryland added, "It made me sick to think this guy was executed based on this investigation. They executed this guy and they've just got no idea, at least not scientifically, if he set the fire or if the fire was even intentionally set." Willingham was convicted of capital murder after arson investigators concluded that 20 indicators of arson led them to believe that an accelerant had been used to set 3 separate fires inside his home. Among the only other evidence presented by prosecutors during the trial was testimony from jailhouse snitch Johnny E. Webb, a drug addict on psychiatric medication, who claimed Willingham had confessed to him in the county jail. Evidence discovered years after the Willingham execution showed that the prosecution had given Webb favorable treatment, then deliberately elicited perjured testimony from Webb that he had been promised and given nothing for his testimony. The Marshall Project, August 3, 2014. Some of the jurors who convicted Willingham were troubled when told of the new case review. Juror Dorinda Burkowski asked, "Did anybody know about this prior to his execution? Now I will have to live with this for the rest of my life. Maybe this man was innocent." Prior to the execution, Willingham's defense attorneys presented expert testimony regarding the new arson investigation to the state's highest court, as well as to Texas Governor Rick Perry. No relief was granted and Willingham was executed on February 17, 2004. Coincidentally, less than a year after Willingham's execution, arson evidence presented by some of the same experts who had appealed for relief in Willingham's case helped free Ernest Willis from Texas's death row. The experts noted that the evidence in the Willingham case was nearly identical to the evidence used to exonerate Willis. 10. Sedley Alley, convicted in 1987 and executed in 2006. Sedley Alley was convicted and sentenced to death in 1987 for the rape and murder of Lance Cipuano Suzanne Collins. near the barracks of the Naval Air Station in Millington, Tennessee. The lawyers appointed to represent him at trial failed to investigate glaring inconsistencies between the physical evidence and a confession Allie consistently said had been coerced. Instead, with no prior history of mental illness, they argued that he suffered from a multiple personality disorder and was not guilty by reason of insanity. In 2003, after Allie had lost his appeals, new lawyers were appointed to represent him in clemency proceedings. The clemency lawyers found numerous inconsistencies in the state's evidence, unearthed evidence that pointed to another suspect who fit the eyewitness descriptions of the murderer and had a car that matched descriptions of the murderer's car, and discovered that Allie had been at home under police surveillance at the time Collins was raped and killed. Based on these discoveries, they asked for DNA testing of clothing and the murder weapon. The evidence persuaded the Tennessee Board of Parole to recommend that then-Governor Phil Bredesen stay Allie's execution and order DNA testing. Instead, Bredesen directed the lawyers to present their request for testing to the Tennessee courts, which refused to allow the testing to occur. 5 years later, the Tennessee Supreme Court disavowed its decision in Allie's case, saying they had misapplied Tennessee's Post-Conviction DNA Testing Act. On May 1, 2019, after new evidence suggested another man may have committed the murder, the Innocence Project filed a petition in Shelby County Criminal Court on behalf of Allie's estate, renewing Allie's request for DNA testing. The courts got it wrong in 2006 when they allowed Mr. Allie to be executed before testing the DNA. Innocence Project co-founder Barry Scheck said, "If Mr. Allie were alive today, he would be entitled to DNA testing under the statute. We now have a chance to learn the truth in this case." 11. Troy Davis, convicted in 1991 and executed in 2011. After a hearing on September 19, 2011, the Georgia Board of Pardons and Paroles denied clemency to Troy Davis, despite presentation of testimony casting doubt on his guilt. Brian Kammer, one of Davis's attorneys, said, "I am utterly shocked and disappointed at the failure of our justice system at all levels to correct a miscarriage of justice." Davis's claims of innocence received international attention, and calls for clemency were made by Pope Benedict XVI, former President Jimmy Carter, former FBI Director William Sessions, former Georgia Supreme Court Chief Justice Norman Fletcher, and others. Doubts about Davis's guilt were raised when some prosecution witnesses changed their stories after giving testimony against Davis, including accusations pointing to another suspect as the murderer of a police officer in Savannah. The board heard testimony from a juror in Davis's original trial who now says she has too much doubt about his guilt and would change her verdict. They also heard from a witness who originally testified against Davis, but has since recanted her testimony, and from Davis's family. The board had held 2 previous clemency hearings for Davis, but the makeup of the board had changed since he was denied clemency in 2008, and new testimony had been given at a federal court hearing in 2010. Davis was executed late on the night of September 21, 2011. The U.S. Supreme Court delayed the execution to consider final appeals, but then denied a stay. 12. Lester Bauer, convicted in 1984 and executed in 2015. Texas executed Lester Bauer on June 3, 2015, after he had spent more than 30 years on death row. Bauer unsuccessfully challenged his conviction and sentence on numerous grounds, including that prosecutors had withheld evidence from the defense supporting his innocence claim. Bauer was convicted of the 1983 murder of 4 men in Grayson County, Texas. He admitted that he had met with one of the men to purchase an ultralight aircraft, which he said the others helped him disassemble and load into his truck, but he consistently denied any involvement in the killings. The evidence against him was circumstantial: calls made to the man selling the aircraft, and Bauer's possession of the same type of ammunition that was used in the killings. Prosecutors obtained the conviction in part by arguing that the ammunition provided a vital link between Bauer and the killings because that type of ammunition was extremely rare. After Bauer's conviction, his lawyers obtained records from the FBI and prosecutors showing that the ammunition was not as rare as prosecutors had said, and learned that prosecutors had withheld information about a tip to police that the murders may have been connected to drug trafficking. Later, a woman came forward saying that her boyfriend and his friends had committed the murders after a drug deal had gone wrong. The wife of one of the other men corroborated her story. In a court filing shortly before his execution, Bauer's attorneys argued, "This is a case in which there is a significant lingering doubt regarding guilt or innocence." In addition to issues related to his innocence, 3 Supreme Court justices said that Bauer should have been granted a new sentencing hearing as a result of what they called a glaring constitutional error that impaired the jury's consideration of mitigating evidence in his case. 13. Brian Terrell, convicted in 1995 and executed in 2015. Just before 1 a.m. on December 9, 2015, Georgia executed Brian Terrell. It took a nurse nearly an hour to find a vein for the lethal injection IV, and as the execution drug was being administered, Terrell mouthed the words, "Didn't do it." His lawyers argued that no physical evidence linked Terrell to the murder, and that his conviction and death sentence were the product of prosecutorial misconduct and false and misleading testimony. Physical evidence from the crime scene leaves substantial questions as to Terrell's guilt. Footprints found near the victim's body were smaller than Terrell's feet, and none of the 13 fingerprints found by investigators matched his fingerprints. Georgia tried Terrell 3 times. The first trial ended in a mistrial when jurors could not agree on whether he was guilty. The second resulted in a conviction that was later overturned by the Georgia Supreme Court. The third trial concluded with a conviction and death sentence. The key testimony against Terrell came from his cousin, Jermaine Johnson, a witness whom defense investigators say later admitted to having lied to save himself. Johnson spent a year in jail facing the threat of the death penalty before he made a deal with prosecutors to testify against Terrell in exchange for a 5-year sentence. Johnson told defense investigators that police and prosecutors had pressured him into giving false testimony against his cousin. Terrell's lawyers argued that prosecutors also presented misleading testimony, suggesting that a neighbor had seen Terrell at the murder scene, when in fact she had told authorities that he was not the man she had seen. At Terrell's trial, the prosecutor emphasized the importance of Johnson's testimony, saying during his closing statement, "If you never heard anything about Jermaine Johnson in this case, if he had never testified, would you have enough information to make a decision in this case? You wouldn't." 14. Richard Masterson, convicted in 2002 and executed in 2016. Texas executed Richard Masterson on January 20, 2016, amid questions as to whether any murder had occurred at all. Masterson had sought a stay of execution based on what his lawyers alleged was evidence of state fraud, misconduct, and his actual innocence. Masterson's filings challenged the forensic testimony presented by the prosecution in the case, the accuracy of instructions given to jurors, and the constitutionality of Texas lethal injection secrecy law. Medical examiner Paul Schroed, after having been told that Masterson had confessed to putting a sleeper hold on the victim during an episode of erotic asphyxiation, ruled Darren Honeycutt's death a homicide and testified that Honeycutt had died by strangulation. Masterson's lawyers argued in federal court filings that prosecutors had concealed evidence that Schroed was unqualified to perform Mr. Honeycutt's autopsy, botched the autopsy, falsified his credentials, and gave false testimony in this case and in other capital murder trials. 2 pathologists who examined the Honeycutt autopsy data say that the Schroed was unqualified and incorrectly ruled the death a homicide when it was most likely caused by a heart attack. In 2010, Ohio Governor Ted Strickland commuted the death sentence of Richard Niels based upon concerns about Dr. Schroed's assertion that the victim in that case had been strangled. Schroed was subsequently fired as chief medical examiner in El Paso County, Texas, after discrepancies were found in his resume and revelations were made about his unsupported testimony in the Ohio case. Masterson's attorneys argued that Masterson falsely confessed to the murder charges during a period of withdrawal from addictive stimulants in which he exhibited suicidal behavior. In a separate filing, they challenged the fairness of his trial because the judge had failed to inform jurors that they could have convicted Masterson of a lesser offense rather than capital murder. A third filing had challenged the constitutionality of Texas's lethal injection secrecy law, which prevented inmates from obtaining information about the source of the state's execution drugs. 15. Robert Pruett, convicted in 2002 and executed in 2017. Texas executed Robert Pruett on October 12, 2017. After the Texas courts deemed DNA evidence in his case inconclusive and denied him a stay of execution to further review the evidence in his case, Pruett was sentenced to death in 2002 for the 1999 stabbing death of Officer Daniel Nagel, a state correctional officer who was at the center of a prison corruption investigation. Pruett had long maintained that he had been framed for the murder. Earlier on the day of the murder, Officer Nagel had given Pruett a disciplinary write-up for eating a sandwich in an unauthorized area. A bloody shank and a torn-up copy of the disciplinary report were found next to the officer's body. Pruett had no history of prison violence. The prosecution's case turned on dubious testimony from prison informants and the junk science testimony of a forensic analyst who linked the tape wrapped around the handle of the shank used to kill Nagel to the prison craft shop in which Pruett's cellmate worked. A state investigator's notes that had not been disclosed to the defense revealed that a key prison witness, Harold Mitchell, had been promised a transfer to a prison close to his family's home in Virginia if he testified against Pruett, and had been threatened with being charged with Nagel's murder if he did not. Pruett's post-conviction lawyers later debunked the forensic methodology the state's expert had used to link the tape on the murder weapon to Pruett, and results of a subsequent DNA test of the murder weapon found DNA that did not match either Pruett or Nagel. According to Pruett's clemency petition, Officer Nagel had been working to identify corrupt correctional officers who had been helping prison gangs launder drug money, and Nagel's name had been discovered on a secret note that had been passed between inmates, which said that a prison gang wanted the officer dead. The same day Pruett was indicted, 4 correctional officers were indicted on federal bribery charges for participating in a drug smuggling ring. Pruett's lawyers argued that the unidentified DNA may belong to the person who killed Nagel. 16. Carlton Michael Gary, convicted in 1986 and executed in 2018. Georgia executed Carlton Michael Gary on March 15, 2018, without any federal court review of substantial evidence suggesting that he did not commit the crimes for which he was convicted and sentenced to death. Prosecutors argued that in the late 1970s, a single serial rapist and murderer killed 3 elderly white women and burglarized and raped a half-dozen others with a signature style that led the media to salaciously dub him the stocking strangler. But if, as the prosecution insisted, a single person committed these murders, evidence that was never presented to the jury and never considered by any federal court suggests that it couldn't have been Carlton Gary. Although Gary was charged with 3 rapes and murders, the prosecution presented evidence of other uncharged crimes under the theory that they had all been committed by the same person. The most damning of that evidence was the eyewitness testimony of a surviving victim who dramatically identified Gary as the person who had raped her and tied a stocking around her neck. However, a police statement withheld from the defense indicated that the witness had initially told investigators that she had been asleep and her bedroom dark at the time of the assault, and she could not describe, let alone identify, her attacker. Post-conviction DNA testing of semen stains on the victim's bedclothing excluded Gary. Gary sought to test DNA evidence from other crime scenes that was in the possession of the Georgia Bureau of Investigation, but as a result of improper handling, the samples had been contaminated and were untestable. During the post-conviction process, Gary learned that police had made a mold of a bite mark from one of the victims and had consulted with a leading forensic odontologist, but had never presented him as a witness. When that expert examined the mold, he concluded that the markings could not have been made by Gary. Shoe print evidence from the scene was also withheld from Gary's defense team until 20 years after his trial. The size 10 print found at one of the crime scenes could not have been left by Gary, who wears size 13.5 shoes. Finally, police claimed that Gary had confessed to participating in the crimes, but not to raping or murdering the victims. But police neither recorded nor contemporaneously documented his alleged statement, which he denied making, and his lawyers argued that the supposed statement fits all the recognized hallmarks of a false confession that never happened. In his unsuccessful clemency petition, Gary's lawyers argued, "We are not talking about questionable recanting witnesses who came forward long after trial, but hard physical evidence of innocence." The Georgia Board of Pardons denied the petition. 17. Dominic Ray, convicted in 1999 and executed in 2019. Alabama executed Dominic Ray on February 7, 2019. Ray's execution attracted national attention when Alabama refused to permit his imam to be present in the execution chamber in circumstances in which Christian prisoners were provided religious comfort by a Christian chaplain. However, Ray had also argued that he was innocent and that the evidence against him was false and unreliable. Ray was convicted in July 1999 of the alleged rape, robbery, and murder of 15-year-old Tiffany Harville in Selma, Alabama. No physical evidence linked Ray to the murder, and the only evidence that Harville had been raped and robbed came from a severely mentally ill man, Marcus Odell, who confessed to the crime and avoided the death penalty by implicating Ray. Odell was also the only person who placed Ray in Selma at the time of the murder. In February 1998, Odell's lawyers sought the appointment of a clinical neuropsychologist to evaluate him in preparation for potential mental health defenses to present in his own trial. The prosecution objected, claiming Odell has no mental impairment. In its opening statement at Ray's trial, the prosecution told the jury that Odell was fine and that there was no question about his mental ability. In fact, Alabama Department of Corrections records that were never disclosed to Ray's lawyers showed evidence of Odell's mental illness as early as 1994. The records documented that Odell had been diagnosed with serious mental illness, psychosis, and schizophrenia, that he was suffering from hallucinations and delusions, and exhibited signs of bizarre speech and distortions of cognition, and that he had a propensity for lying. Ray was convicted, and after a one-day penalty phase, a non-unanimous sentencing jury recommended 11, one that he be sentenced to death. In September 1999, the trial court imposed the death penalty. In 2017, Ray's federal habeas corpus lawyers interviewed Odell, who for the first time told them about his schizophrenia diagnosis, and signed a release authorizing them to obtain his mental health records. The records documented prosecutors' knowledge that Odell had schizophrenia and was suffering from delusions and auditory hallucinations when he accused Ray of the rape and murder and testified against him. Ray's lawyers argued that the prosecution's deliberate suppression of the mental health evidence, despite being aware of Odell's mental illness, violated Ray's right to due process and entitled him to a new trial. As Ray attempted to litigate that issue, Alabama prosecutors successfully petitioned the state courts to set Ray's execution date. The Alabama state and federal courts dismissed Ray's due process claim, and on the day of his execution, the U.S. Supreme Court declined to review the merits of his prosecutorial misconduct claim. 18. Larry Swearingen, convicted in 2000 and executed in 2019. Texas executed Larry Swearingen on August 21, 2019. Despite significant flaws with virtually every piece of forensic evidence in his case, and strong evidence that it was physically impossible for him to have committed the crime. His conviction was grounded in what his lawyers described as false and misleading junk science testimony that were later rebutted by numerous forensic experts. That included false expert testimony linking Swearingen to the murder weapon, false testimony dismissing exculpatory blood evidence, false cell tower testimony, and false testimony concerning the time of death. They are going to execute someone that the legitimate forensic science has proven innocent, Swearingen's appeals lawyer, James Ridding, told the Texas Tribune. And the execution is going through on the basis of other forensic science that is borderline quackery. In fact, it is quackery. Swearingen was sentenced to death in July 2000 for the murder of Melissa Trotter, who was strangled with a pair of pantyhose and whose body was later dumped in a state forest. A county medical examiner testified at trial that Trotter had been dead nearly a month at the time her body was discovered. She later recanted that testimony, saying Trotter died no more than 2 weeks before. 8 other experts, including forensic pathologists, forensic entomologists, and a forensic anthropologist, agreed with that assessment. However, given that time of death, it was impossible for Swearingen to have committed the murder. 3 days after Trotter's disappearance, Swearingen was arrested for outstanding traffic warrants and was still in jail 3 weeks later, when Trotter's body was discovered. The evidence linking Swearingen to the murder also was scientifically suspect. Trotter was strangled with one leg of a pair of pantyhose. A Texas crime lab technician falsely testified that pantyhose found in his Swearingen's home were a unique physical match to the ligature, to the exclusion of all other pantyhose. In closing argument to the jury, the prosecution called this evidence the smoking gun of Swearingen's guilt. However, the technician's notes of her initial examination of the evidence, which were withheld from the defense at trial, indicated that she initially had found no physical match between ligature pantyhose. The defense presented expert testimony pantyhose from a Cal Poly Pomona professor of textile science that the two hose were cut in the same basic silhouette, but they were not cut from the same piece. These are not a match, and certainly not to the exclusion of all other pantyhose. Weeks before the execution, the Texas Crime Lab director, Brady W. Mills, released a letter admitting that the technician's trial testimony was overstated. Shortly before the execution, Mills also conceded that testimony by a crime lab serology expert dismissing exculpatory blood evidence had also been inaccurate. DNA testing of blood flakes found under Trotter's fingernails produced a DNA profile of an unidentified male that excluded Swearingen. The serologist testified without any scientific basis that the blood excluding Swearingen came from contamination, either at the time the sample was being collected, at autopsy, or after the sample was being collected. 19. Walter Barton, convicted in 1993 and executed in 2020. Missouri prosecutors tried Walter Barton 5 times for the brutal 1991 stabbing death of 81-year-old Gladys Quayler. Twice, Barton's convictions and death sentences were overturned because of prosecutorial misconduct. 2 other times, the trials ended in mistrials. Barton was one of 3 people, along with a neighbor and Quayler's granddaughter, Debbie Selvage, who discovered her body. He consistently maintained that he pulled Selvage away from Quayler's body, getting droplets of Quayler's blood on his clothes. His conviction rested on junk science testimony that small blood stains on his clothes had been impact stains from high-velocity blood spatter, which the prosecution argued occurred while Barton was purportedly stabbing Quayler. However, a 2015 analysis by crime scene analyst Lawrence Renner concluded that the blood stains on Barton's clothes were actually transfer stains, likely caused by contact with other bloodstains. Quayler had been stabbed 50 times, and Renner said that the perpetrator of such a grisly murder would have been covered in the victim's blood. Prior to his execution, 3 jurors who had voted to convict Barton signed affidavits saying that the new analysis of evidence from the case would have affected their guilt stage deliberations. In addition to the blood spatter testimony, prosecutors presented testimony from a jailhouse informant, Catherine Allen, who had been convicted 29 times for fraud, forgery, and related offenses. Allen claimed that Barton had confessed to her and then threatened to kill her, like he killed that old lady, if she disclosed his alleged confession. Allen lied to the jury that she had only 6 convictions and that she had received no benefits for implicating Barton. Prosecutors withheld from the defense the fact that they had dismissed an additional case against Allen in exchange for her testimony in Barton's 5th trial. 20. Nathaniel Woods, convicted in 2005 and executed in 2020. Nathaniel Woods was sentenced to death after a non-unanimous jury sentencing recommendation in August 2005 for the killings of 3 Alabama police officers. His case featured several hallmarks of wrongful conviction: official misconduct, coerced informant testimony, and racial discrimination. Prosecutors acknowledged that Woods' co-defendant, Carrie Spencer, shot the officers in an incident in a drug house. Spencer, who received a life sentence in his trial, has consistently maintained that he shot the officers in self-defense after they had beaten Woods during a shakedown and then pointed a gun at Spencer. Knowing he was not the shooter, prosecutors offered Woods a plea deal for 25 years, but Woods' lawyer advised him not to take it, misinforming him that he could not be convicted of capital murder as an accomplice.